You may proceed.
Thank you, Your Honor. May it please the Court, I'm Dave Domina. I'm here on behalf of Thomas Stallnaker, who is appointed as receiver on behalf of the Securities and Exchange Commission of the United States to receive the assets of Brian Behrens, his corporations, one of which bears his name and another of which is called National Investments Incorporated. Among the assets that the receiver found upon taking charge of the documents and records and materials of Behrens and his companies was a claim for professional negligence. I was asked to bring that claim. Mr. Behrens was indicted for crimes. Mr. Behrens had the attorney-client relationship, as did his corporations. They are parties necessarily. They have no ultimate stake in the outcome of this litigation, because if it's successful against the lawyers, the assets go to the receivership for the benefit of the victims of Behrens' crimes. Mr. Behrens was not cooperative because his criminal defense lawyer encouraged him not to be cooperative with the prosecution of this case to this extent. Mr. Behrens refused to waive his Fifth Amendment privilege against self-incrimination. He refused to answer written interrogatories, the answers of which might have incriminated him, and he insisted on waiting until after his criminal case was tried before participating in this one. The receiver had all of Behrens' books and records. The receiver took over all of that material and made it available in discovery responses in this case. The defendants, the appellees here, never bothered to look at that material, but complained they got no discovery. The trial court below...
Go ahead with what the trial court, because I have a question on the order, if there is an order.
All right. Thank you, Your Honor. The trial court below issued two orders. One of those orders overruled a motion for summary judgment brought by the appellees. They have an appeal on that issue. An order overruling summary judgment's not a final order. I don't think that
But the order compelling discovery, is there a written order on that?
Only a journal entry.
And so what was sustained and what was overruled, or do we know?
The trial court gave Mr. Behrens a period of time within which to respond to interrogatories. He had already said he would not waive his Fifth Amendment. He then responded further to the trial court's order with his lawyer's affidavit, David Stickman, the federal public defender's affidavit, saying that Mr. Stickman had advised his client to invoke the Fifth Amendment and declined to answer. That's all the record the trial court had. There is no finding as such until the dismissal order of failure to comply with a requirement to respond to written interrogatories. In the dismissal order, the trial court said, you didn't respond, you don't have a Fifth Amendment privilege in this civil case, and therefore I'm dismissing your case because you're not participating in discovery. We think the trial court committed two really fundamental errors in that order. The first one is the trial court really misapprehended who the plaintiff is. It's true that Mr. Behrens is the first named plaintiff and is a real party in interest, but he's not the real party with the ultimate interest in the outcome in terms of receiving assets.
Doesn't really make any difference.
I think it does, Your Honor, and I think it does because the question of what sanction is appropriate requires an assessment of the benefit to the recalcitrant party, particularly when it's a Fifth Amendment issue, the Fifth Amendment is invoked, and the detriment to that party.
You're saying under a balancing test the next bit.
Yes, because here the problem is Mr. Behrens, who invoked the Fifth Amendment, suffers no penalty from the dismissal. Only the receiver suffers a penalty from the dismissal. This dismissal means the receiver has no chance to recover assets for the victim of Mr. Behrens' wrongdoing. Mr. Behrens doesn't get the money.
Is there any other penalty suffered by any other party?
No, I don't think so, Your Honor, because the only ultimate financial beneficiary of this effort is the receivership. So dismissal simply thwarts the receiver. Mr. Behrens, as a result of the dismissal order, doesn't have to respond to the interrogatories, which may not mean anything to him now because the criminal case is over, but he suffers no disadvantage because he had nothing to get here, with the exception of compliance with a civil federal court order upon appointment of the receiver that said cooperate with the receiver.
Are there cases out there that characterize delay as a penalty suffered by the party not invoking the fifth?
Well, there are cases that say that it's appropriate that one assess whether the delay is so substantial that dismissal is an appropriate sanction.
Are you back to the balancing line of cases?
Well, I'm at balancing plus progressive punishment. The second part of the trial court's error here is that there was no effort at progressive enforcement of discovery.
I'm a little bit trying to get back to maybe what Justice Conley was going with. There's motions to compel, or there protective orders. I'm not sure what the
Nope, there was a motion.
history
There was a motion by Mr. Behrens to stay the proceedings. There was no motion for a protective order. There was a motion to compel. It was sustained with a journal entry and without an order, I think.
Were there more than one motion to compel?
I don't recall that there were. I believe there was one.
Well, let me go back again to your first point. You're saying that if this case were to go to fruition, then the recipients of money, if successful, would be
The receiver.
the receiver, or the beneficent purposes of the receiver.
So, do you recall when the complaint was filed and then when it was disposed of as the dismissal order? How much time?
Your Honor, the complaint was filed on December 8 of 2008, and the dismissal order was March 2 of 2009.
And if I correct, was there a bankruptcy? Blunk's bankruptcy was in that period of time?
There was a bankruptcy proceeding, I believe, on July the 16th. The bankruptcy filing was August 11, pardon me, of 2009. That was Blunk's bankruptcy. Now,
was there an automatic stay as of that date?
Well, there was an automatic stay at least as to Blunk, or as to Behrens, Your Honor. Probably not as to the other party, which really is the only truly active party. And that series of questions prompts me to make what I think is a critically important observation here. The finding of non-compliance with the order to compel is a finding against Behrens. There is no finding that Stalnaker failed to comply. Stalnaker did all he could do. Stalnaker gave up all access that he could offer to all of the documents in his possession. Stalnaker said, come see what I have, see what I found, and take a look at anything I have. I'm holding nothing back from you. Stalnaker could not give a deposition because he had no first-hand experience. Behrens refused to give one and refused to answer interrogatories.
What was Stalnaker's role?
He was the receiver for the SEC.
Okay.
How much time elapsed from the order of dismissal until, was it a trial that was scheduled in April?
Yes, Your Honor. The trial was scheduled to commence on April the 12th, and the dismissal was March the 2nd.
And the court, if I remember correctly, the court was advised somehow
Yes.
that there was a trial scheduled.
Mr. Stickman's affidavit identified the trial date. I don't recall if we added a copy of the federal court's trial order, which was out and available at the time, so I'm not sure we did it both ways. But yes, the district court knew of the trial date. And the district court knew that one way out of this quagmire was simply issue an order that said, Behrens, you've got to give the deposition within 2 weeks after your trial concludes.
But they might argue, and I think maybe they brought up in their briefs, that then you would have, or somebody, Behrens would have appealed, and that would have prolonged it even further.
That's possible, but you know, we have to deal with the record we have and not the record we might have, and that isn't the record. The record we might have, which they hypothecate, is not before you. The real record before you is that this was a 6-week question in a case that was 5 months within your trial guidelines in any civil case. It's also a case in which there's a remarkable tension present. It would mean, if their position is successful, here's what it would mean. Someone who violates the securities laws of the United States and swindles investors and is sued civilly so the SEC can take all of his assets has the best chance to hold on to the assets by being indicted, invoking the Fifth Amendment, not cooperating with the receiver, and hoping there's something left out at the end. That's what they argue for. And that's the outcome of this. Behrens has no motive to cooperate with this receiver. The receiver has a motive to try to get to the question, was there a lawyer involved in this scheme? And is there some money for the investors as a result? That's what we're trying to do.
Were the materials that Stalnaker turned over enlightening
They were
on
never,
this issue?
They were never inspected by the other side, and they are not in the record. However, there's enough in the record to know that they include email between the lawyers. There's enough in the complaint and in the record to know that they include belated drafts of minutes, a plan for corporations to be used in a particular way, drafts of the promissory notes that were the financial instruments, and very interesting things that they could have seen.
Is this the correct statement of the record? Stalnaker rolled over and produced all the documents, and some of them include materials with respect to the attorney-client deal. Is that correct?
And no privilege was ever invoked, except the Fifth Amendment privilege by Behrens. Thank you, Your Honors. We
Thank
ask
you.
that you reverse.